While progress has been made in recent years, evidence shows that the criminal justice process for rape and serious sexual offences is still flawed, and more can be done to ensure these offences are tried justly without traumatizing complainants. Our recommendations aim to improve the understanding of consent and sexual harm by countering the effects of rape myths, improve the treatment of complainants, and ensure that defendants receive a fair trial. One issue particularly detrimental to the fair and effective trial of sexual offences is the risk that rape myths can permeate the criminal process, influencing jurors' deliberations. Rape myths are genuine and sincere beliefs that are factually incorrect and often derived from stereotypes. For example, that rape will always be reported promptly or that victims will physically resist. These myths do not reflect the variety of experiences of and reactions to sexual violence. We consider restrictions on certain types of evidence that carry the most risk of introducing rape myths and infringing complainants' right to privacy and dignity. We recommend enhanced scrutiny of requests to access complainants' personal records, including their therapy notes, and new rules on the admissibility of evidence of their sexual behavior or claims for criminal injuries compensation. We conclude that complainants should have the right to be heard on requests to access their personal records and for applications to introduce evidence of their sexual behavior, and that they should have independent legal advice and representation to support this. We recommend improvements and additions to the directions which judges give to jurors to educate them about myths and misconceptions. In addition, we conclude that parties should be able to introduce expert evidence of behavioral responses to sexual violence, in particularly complex trials. To effectively operationalize these recommendations, we recommend the introduction of specialist sexual offences courts within existing buildings. We've provided our report to the government, and they will decide which of our recommendations they wish to take forward. We acknowledge that the criminal justice system is facing significant challenges due to strained resourcing and court backlogs, with consequent impact on judges, practitioners, and participants. This wider context and the efforts of others to address these difficulties will be one of a number of considerations for the government when deciding on implementation.